Nsem-Pii TV nie.
Jamamo akwa babiem edeba Nsem-Pii TV platform yi eso. Now, Speaker of Parliament Alban Bagbin and afidie wa jinani so. Babi a jinani so. Babi amatumi die edi ni trimwa oka bibia kire na wontie. Na tiefo ebekaya. Baby bi obekubia odenam ebo no hosafo hene. Se Ghana hano ura the corridors of power ono ene number 3. Another Nkweku-Addo ne number 1. Dr. Alban number 2. Ono Bagbin say on number 3. Enti no nso kura tumi wo Ghana ha. So you're nobody determined, nobody can call him to order. And no any Ghana yamamra enhihye ya odi ebaye since time immemorial concerning separation of powers. Yes. Executive, the legislature, and judiciary, checks and balances, and no name Supreme Court, the learned Attorney General Godfrey Yeboah Dami educated the bench with regards to a certain bill, a friend of Human Rights, Sexuality, and Family Value Bill. Speaker of Parliament Alban Bagbin. Edi huhuruye, ene yakakabensem, edi tumu se on they were passing as bill no. Attorney General and Fifemu any presentation documents articles or site here based on constitution amana bededi say adia Bagbin or parliament no it is so unconstitutional etia Ghana mara etia timemufu ankasa ye wo man mu adia na Bagbin ejitu mo parliament na adia etia yankasa ye fa hodie adentia number 1 Attorney General ama yehunu say sa bill na ojitu mu no say bill no impose charges on Ghana's consolidated fund and other public funds. Yes, adia yenyan ye oman mu nyina adwen kire ehunu say ye preso anase ye preso no Bagbin de pitupuru akwakogia tu. Number 2, a Sanskrit article 108 of the Constitution. I know she say BBC in beba so I just say if the president home number and your private members bill and ebenam so our BBC yaja to our parliament. Na okay kasa nyema we nyina boma the Attorney General ne am Supreme Court judges ne hu say debi ade we course we dey enya kora ne mukwase obi atisa de we in sub-Saharan Africa say BBC pan etimi akoso Ghana the beacon of democracy na asif himself. The president continues to be praised say omode ade we betu na no wan som wan entertain this bill no kra e wo ho no. Na the Attorney General has really spoken and dedicated both the Supreme Court bench and Ghanaians. Yenti ene the presentation inside the apex court of the land.
Then we rely on our statement of.
I believe that you rely on your submissions in the current case will be totally in tandem with what you have already said.
Yes, indeed that's so. I mean, and I don't want to bore the court with a repetition of those arguments. So to develop just one point, the facts about the prohibition that I stated is implied in Article 108. The prohibition on Parliament from proceeding with the bill. I argued fully on that, but I'll develop the argument further by stating that prohibition on Parliament from proceeding unless certain factors have been met actually implies a condition precedent to Parliament's power to act upon such a bill at all. My lady, I will state further that indeed that prohibition actually then operates as a fetter on Parliament's power from proceeding because it's a condition precedent. Without the satisfaction of that condition precedent, every step taken by Parliament is null, void, and of no effect. Especially if that is the case, the question arises whether indeed
there's even a bill.
There's a bill at all. Or there can even be a cure, a remedy for the default of the Speaker of Parliament in proceeding. Early on, my lady would observe that I actually made a point in answer to a question from the court that I would be hesitant in stating that the Speaker did not make such a determination, and I would rather say that there was lack of evidence of such a determination. Clearly now I've seen evidence of the omission So I would amend my earlier submission to say that the Speaker actually omitted because there has been such clear concession by the first defendant in his statement of case, where he stated that the Speaker did not present such a determination at all. Already, I will state that, so clearly, there was nothing, no basis on which Parliament could proceed, because there was a failure to satisfy the very important condition precedent of the Speaker or the person presiding, presenting an analysis of the impact on the consolidated fund. And simply, I would further submit that such an omission cannot be cured by the President's election to refer the bill back to Parliament for reconsideration. Indeed, what if the President does not refer the bill back to Parliament? It means the nation lives with their own constitutionality. That would clearly be the implication. If the President decides not to present the bill back to Parliament, the nation will live with such unconstitutionality. And that will be a huge scar on the constitutional landscape of the nation. I simply submit that there's again no independent power of Parliament to reconsider a bill after the processes in Article 106 of the Constitution have been satisfied, which indeed have been up to this stage. Parliament has fully exhausted all the processes of considering a bill. The bill has been introduced in Parliament, has been read for the first time as required under Article 106, Clause 4 of the Constitution. It has been referred to the appropriate committee of Parliament under the same Article 104, Clause 4 of the Constitution. There has been a deliberation. There has been a deliberation upon the bill by the appropriate committee as required by Article 106, Clause 5. Indeed, the bill has been read for the second time. It's been subjected to full debate as required by Article 106, Clause 6. And indeed, it has been read for the third time. It has been passed by Parliament. Especially, my submission is that upon the satisfaction of all these steps required under Article 106, there is no room for Parliament on its own to reconsider such a bill. And therefore, there is no provision for a remedy or a cure of a failure to comply with Article 108, Paragraph A of the Constitution.
Honorable Attorney General.
Yes, especially.
Did I hear you say that after a bill has been assented to and it's become an act, that there's no other opportunity to take the matter on?
No, it's definitely not.
I didn't hear you right.
No, it's
I am glad.
The point, yes, the point I made is
even on closure at the bill stage, Parliament's rights are exhausted, or Parliament's capacity, authority is exhausted.
Yes, that
I cannot receive the bill
on its own.
On its own.
Yes, that at the stage we are, Parliament's power to independently review the bill or provide a remedy or cure, as earlier on advocated by my learned friend, does not exist.
No. What your learned friend is saying, which I think is compatible with what you're saying, is that it is the President who can tell them that there is this defect, and so cure it.
Right.
Yes.
And then he also
and Mr. Abedu says that supposing the President doesn't do that, the nation will have to live with an unconstitutionality.
Precisely. And that's the point I make, that indeed, so it is up to the President to do that. And I respectfully made the point that at this stage, Parliament cannot independently do anything at all. And if the President also does not elect to refer the bill to Parliament or even to Council of State, then the nation lives with their own constitutionality. And I made the other point that it would be incongruous for Parliament or the nation to be, for such a bill to be foisted on the nation purely on account of an omission of the Speaker of Parliament to undertake an act which is required by Article 108, Clause 8, which is make a determination, which clearly is not in doubt at this stage.
Honorable Attorney General, do I understand you to be saying that if you, as legal advisor of the government, if you offer an opinion on something, the government won't listen, the president won't listen, and will sign anyway, even if you tell him, no, don't sign this one?
Respectfully, no. You see, that's the point I'm making. That is why I preceded my arguments in the other matter with on the basis that indeed I made all these submissions, not to assist the court to determine a case, it is to settle a question. And the question I respectfully want the court to settle is whether indeed a bill passed in flagrant violation of Article 108 Clause A, which enjoins the person presiding to make a determination, is valid or not. But the issue for me goes beyond the substance of this bill. So indeed, we must look at, with all respect, the bigger picture. That and now private members bill has come to live with us. Every day things are coming up and all. Even now, there's actually a dispute as to whether a bill that has been passed and assented to by the president is actually constitutional or not, which is the witchcraft bill, also amendment bill or witchcraft bill, which again the president actually sought to recall, because indeed after that bill was assented to by the president referred it to the Office of Attorney General for advice. And I said that no, it clearly held implications for the taxpayer because it implied violation of Article 108. And then the president sought to recall his assent to the bill, and it created a very huge chaos. So essentially, I would entreat the court to indeed deal with this issue quite seriously. You said
you will entreat us, yes, not to injunct, but to hold the status quo.
Yes.
Now, are you inviting us to injunct?
So it's the same. I think the import will be the same.
You are vacillating.
Okay. No, I think the import or the effect of holding a status quo pending the determination of the action will be to prevent the bill from progressing.
Do round up.
Yes, but the point I think maybe I want to clarify that point. It's very important. Maybe that's the point of which I will end. That indeed it is important for the court to settle this question, to be given the opportunity of settling the question, and then pending the settling of that question or determination of that question by the court, I think that the parties ought to hold their hands for the court to be given an opportunity. I believe that brings greater clarity to the Honorable Lady Chief Justice.
I'm not done, and some new information has just come to me in the short break, which I'll make available to the court very soon. But most importantly, I need to react to a few points made by counsel for the plaintiff and also the Attorney General. The point about whether if this bill ripens into an act, the whole nation is false with an unconstitutionality doesn't arise at all, especially even in the context of the instant application. I cited the case of Commission on Human Rights versus Attorney General to the courts. 1998 Supreme Court of Ghana Law Report, page 894. Justice Hifron Benjamin took pains to explain this point, that especially when a lot of your reliefs, final reliefs, are declaratory in nature, the court is even more reluctant to intervene by way of an injunction, because at the end of the day, the act will be declared null and void. And so then also there's this argument which also corroborates my case in terms of fact, that the witchcraft bill has come back, that the witchcraft act is now even back for a determination of the question as to its constitutionality, all still corroborating the fact that even if we discount the options that we have now, including his own option of advising the president, I don't want to lose my lady. I don't want to lose my lady somewhere. Very well.
I wonder if you were inviting the nation to live in a messy situation, but
there will be no messy situation. All of that has been anticipated by the Constitution. That certain things will be done, and this court has power to say that whatever you have done is hereby nullified.
And that we shouldn't be coming to this court. You said they shouldn't be coming to this court. That they should be resolving the problems outside of this court because you haven't finished your work.
No, that's not exactly what I'm saying.
I see.
I'm now responding to the specific argument that if no injunction is granted, we are totally helpless at this stage. I'm saying that even if we speculatively decide that the president won't consider any of the options available to him and won't even listen to the Attorney General's own advice, the final reliefs of this court claim declaratory reliefs. And the Commission on Human Rights case that are cited to the court says that to the extent that that can eventually be nullified, the Ghanaians are not damnified. And finally, I am sure he knows that under Article 58 of the Constitution, the president has a responsibility of upholding the laws of the Republic of Ghana. So if he draws his attention to that fact,
everybody, including us,
that is so. But we are
including the speaker.
We are oh yes,
including Parliament.
Oh yes, that is so. But there is a specific provision which deals with the president in this particular matter, and I'm saying that as the first man of this country, if his Attorney General draws his attention to an unconstitutionality, he would definitely take every step to correct it. So we are not helpless at this stage, the way they want it to look like.
Very well. Thank you.
Then there are some specific references.
That is the last one.
That can't be the last one. There's a number of paragraphs have been dealt with in my affidavit that I need to respond to. The paragraph 10 that he dealt with would be answered by the argument that I've just made, because in that particular paragraph, repetition is made to the fact that the president has a discretion as to what to do with it. And my lords, I'll just crave your indulgence to read specifically Articles 106, 7, 8, and 9 of the Constitution quickly. Clause 7 says that where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill, or that he refuses assent to the bill unless the bill has been referred by the President to the Council of State under Article 90 of this Constitution. Then clause 8 says, where the President refuses assent to a bill, he shall within 14 days after the refusal state in the memorandum to the Speaker any specific provisions of the bill which, in his opinion, should be reconsidered by Parliament, including his recommendations for amendments, if any. Inform the Speaker that he has referred the bill to the Council of State for consideration and comment under Article 90 of this Constitution. Then finally, clause 9 says, Parliament shall reconsider. When it is sent to Parliament, it shall reconsider.
Where you probably missed what the Attorney General said, that the Article 108.1 provides a prerequisite action condition.
Yes.
A condition precedent, such that if missed, everything done thereafter is invalid. For legality and constitutionality.
I didn't miss that point. Eventually, if this court decides that there has been an illegality by reference to the Constitution, what it will declare is that there is a nullity. And the question my lady kept asking me earlier is that if in truth there is an illegality and Parliament concedes it, would it correct it or not? So if the President draws Parliament's attention to that, and Parliament agrees with the President, and that's it, it would have achieved the same question that my lady had drawn attention to. So again, no need for the injunction. So that's my answer to paragraph 10. Then he answers my paragraph 12 by saying that my submission, the position in that paragraph that the question as to whether Parliament was quorate or not was raised earlier. My simple answer with that argument is by reference to the Haruna Idrisu, the e-levy case, in which the question arose as to whether Parliament was quorate or otherwise. This court applied the omnia pursuantur rule to it. So I'm using
The e-levy case. You attached evidence of who was in Parliament, and that evidence itself showed that there was quorum, and yet you came here saying that there was no quorum. I was on that panel. I remember very clearly.
But then they refer to paragraphs. I'll get back to that. In paragraphs 13 and 14, they answer it by saying, oh, they are coming in the interest of the public. But their depositions in paragraph 19, which provoked those two depositions from me, refer to the fact that people were being threatened and their human rights violated. The court's jurisdiction is not being challenged to interpret human rights provisions. But insofar as enforcements are concerned, there are also two preconditions. It is the High Court which enforces such rights. And it is the
Nsem-Pii now show on my YouTube channel.
Be the first to know Nsem-Pii TV.